Honorable members of this tribune. Sempre xixi. Nossa, sim, exato. Honorable members of this tribune, colleagues, good morning.
Aí eu sei para quando eles vão China, os troços aqui, né? E aí, para ser nossa vai ser.
Pois, não sei como isso não está com
a câmera está pegando isso aí.
Jeito que tá bom. Não. Tem que melhorar a falta mais. Sim, estamos ao vivo. Estamos ao vivo.
Essa seleção tá 6? Acho que já tá.
Deixa eu olhar para o
First of all, I want to welcome everyone here. It's a real pleasure to be here. And I'd like to know how you divided the time, if you had a specific adjustment of 15%.
And also introducing yourselves.
Yes.
My name is Emma Berenga, and I speak on behalf of respondent on procedural matters. And the parties have settled on communication as an initial 14 minutes for respondent on procedure, followed by 4 minutes again, 1 minute for rebuttal and 1 minute for rebuttal. Then the merits, when it's initiated, will be followed by respondent.
40.
Yes.
Members of this tribunal, good morning. My name is Julie Mart, and I will present respondents on the merits of this dispute.
Members of this tribunal, esteemed opposing counsel, first of all, good morning. My name is Maria Clara Schivano, and I will be speaking on the procedural aspects on behalf of claimants censored as in the present dispute. Thank you.
Good morning, members of the tribunal. My name is Gabriel Figueiredo, and I'll be speaking on behalf of Censor X PLC, the claimant in the present procedure.
So just switch for Gabriel procedure.
Merits.
Sorry, merits. Claimant. Maria. Procedure. Claimant. Ana. Procedure. Response.
Procedure response.
And Julia, merit.
So if you have any question or any anything that you want to say before we start?
Maybe just we have not, we're not sure whether we're going to make questions during the presentation, yes or no, depending on how the tribunal is about the same. But in case we interrupt you, I think we would agree that the time will be staying, okay?
Yes. But I think we'll try to give you the opportunity to finish.
We'll do our best.
Yeah, it's unbearable.
Sometimes it just happens.
So, if,
Members of this tribunal, good morning. Once again, my name is Leonel Berenga, and I'll speak on behalf of the respondent's procedural request. alongside my co-counsel, Julia DeMarc, who will later address the merits of the dispute. Members of this arbitration.
Just a second. Um,
It happens.
Sim. Acho que digitando no áudio, só esse microfone que é da TV aberto.
Tem captação aqui.
Mas acho que agora vai. Pegamos agora.
wait a little.
No, I think we solved the problem. We just need to check, make it again.
Just
So
talk
just,
without
Yeah,
commenting anything, just to make sure.
I heard you already presented yourselves, but maybe again, so that we get the audio correctly.
May I briefly introduce the fact of the case?
I think it's good. I think, I think now we can't hear anything, so if you want to start.
Yeah.
Yes, okay, let's do it.
Restart or? Restart?
Yes, please.
Apologies.
Okay, thank you, thanks.
Members of this arbitration tribunal, opposing counsels, good morning. My name is Anil Varenga, and I'll speak on behalf of respondents' procedural requests alongside my co-counsel, Julia DeMarc, who will later address the merits of the dispute. To quickly introduce the facts of the case, the parties originally signed a framework agreement delineating the sales of sensors. The sales were further detailed by a series of purchase orders, and originally the dispute pertained to purchase order number 9601. However, claimant now wishes to introduce a new claim to proceedings pertaining to purchase order number 815-604. Members of this arbitration tribunal, the only reason why we even have procedural matters to discuss at hand is the sheer untimely nature of claimant's request for the addition of a new claim, and alternatively for the consolidation of the current proceedings with the second arbitration not yet initiated. First, I will address why the addition of claimant's new claim is impossible, regardless of the arbitration agreement it stems from. Second, I will discuss why the new claim should not be added to the current proceedings, considering the requirements of Article 23.4 of the rules. Later, I will discuss why consolidation of the proceedings should also not be granted. Claimant's new claim cannot be included within the scope of the arbitration agreement of purchase order number 9601. However, even if this arbitration tribunal should apply the requirements of Article 6.4.2 of the rules, which sets the conditions for the for raising claims pertaining to different arbitration agreements drafted between the same parties, then these conditions are also not met. First, Article 6.4.2 of the rules requires all arbitration agreements to be compatible. The case at hand, the arbitration agreements of purchase order number 9601 and 815-604 are not compatible. Purchase order number 9601's arbitration agreement demanded an arbitration tribunal composed of 3 arbitrators. However, PO number 815-604's arbitration agreement allowed the arbitration tribunal to be composed of 1 or more arbitrators. This is particularly relevant as Article 12.2 of the rule establishes that whenever the parties have not agreed on the number of arbitrators, then the court shall appoint a sole arbitrator to settle the dispute. Therefore, the 2 arbitration agreements provided for a different number of arbitrators, and they are incompatible. Not only that, but the parties have not consented to a unified determination of claims. According to scholars Jason Fry, Simon Greenberg, and Francesca Massa of the Secretariat's Guide to ICC Arbitration, whenever the parties have drafted incompatible arbitration agreements, they have indicated that they do not wish to determine all claims in a single proceeding. Therefore, the addition of claimant's new claim is impossible regardless of the arbitration agreement it stems from. Not only that, but the addition of claimant's new claim should not be granted, considering the requirements of Article 23.4 of the rules. These are the conditions for the addition of a new claim to proceedings once the terms of reference have been signed, whenever the new claim falls outside the scope of said terms. The requirements established by Article 23.4 are that all claims shall share the same nature, the stage of the proceeding shall be favorable, and the arbitration tribunal shall consider other relevant circumstances. Claimant's new and previous claims do not share the same nature. According to ICC case number 21574, claims do not share the same nature when the new claim introduces a discussion on different contractual violations than the ones that had been analyzed so far. Claimant's new claim introduces a discussion on Article 15 of the Framework Agreement. Article 15 of the Framework Agreement established the form of the notice of defects. Claimant alleges that the sensors traded under PO number 815-604 were defective. However, it did not attempt to contact claimant and the correct form of the notice of defects. Therefore, as claimant's new claim introduces a discussion on different contractual violations that had been analyzed so far, the addition of the new claim cannot be granted. The parties have never referred to Article 15 of the Framework Agreement in the prior submissions. Not only do the claims do not share the same nature, this arbitration tribunal should also consider that claimant could have introduced its new claim prior to signing the terms of reference. If the arbitration tribunal may please follow me to page 49 of the record. Please let me know when you get there. Yes, this is the witness statement of Bertha Durand, who was the head of sales of claimant. Paragraph 7. In the 4th line, second sentence begins with, by that time, the new. Is your tribunal with me?
Yes.
By that time, the new account manager for the LiDAR sensors finally got around to look at the unfinished old projects and realized that the second payment had not been effected. Members of this arbitration tribunal, the sole reason why claimant has not introduced his new claim earlier on in the current proceedings is because it did not care enough to check on the payments pertaining to PO number 815-604 earlier on. Therefore, it did not act with the diligence that can be expected from a company of this economic magnitude. This is why claimant's new claim does not meet the requirement of lack of awareness, for instance, the need to initiate a new claim, which sometimes is considered as a relevant circumstance to the inclusion of a new claim. And the stage of the proceedings could have been a lot more favorable than it really is. Not only that, but often arbitration tribunals consider time efficiency as one of the relevant requirements under Article 23.4. This is further established by Article 22.1 of the Rules of Conduct of the Arbitration. However, the inclusion of claimant's new claim would be detrimental to the time efficiency of the current proceedings. Claimant has resisted respondent's assertion that the censors traded under appeal number A15-604 were defective. Therefore, the analysis of the defective nature of the censors traded under appeal number A15-604 may lengthen the proceedings significantly, and this can be avoided if its new claim is not included. Therefore, the inclusion of claimant's new claim should not be granted by the arbitration tribunal. Not only that, but consolidation of the proceedings cannot and should not be granted. Moving on to my second submission. First, this arbitration tribunal cannot consolidate proceedings. Second, the requirements for consolidation as established by the rules under Article 10, as well as the ones established in the framework agreement under Article 41.5 are not met in the current case. First, this arbitration tribunal does not have the power to consolidate proceedings under the rules. Article 10 only allows the court to consolidate proceedings. And this is reaffirmed by ICC's colors such as Thomas Webster and Michael Buehler of the Handbook Guide to ICC Arbitration. Not only that, but Article 19 of the rules establishes that the parties may only decide on the procedure where the rules have remained silent. This is clearly not the case. Article 10 explicitly states that the court shall consolidate proceedings. Therefore, consolidation of the proceedings is impossible. However, even if we should analyze the requirements for consolidation both under Article 10 of the rules and the framework agreement, these are not met. Article 41.5 of the framework agreement established that the arbitration tribunal should consider the risk of conflicting decisions and the fact that common questions of fact or law among claims. As common questions of fact or law result in conflicting awards, I shall address these two requirements shortly. There is no real risk of conflicting decisions in the case at hand. There is only material conflict among decisions if the claims are the same or if they are mutually exclusive. Claimants' new and previous claims are clearly not the same and they are not mutually exclusive. Deciding on payment under appeal number A15-604 does not affect payment under appeal number 9601. Therefore, there is no risk of conflicting decisions in the case at hand. Even if this arbitration tribunal should consider the requirements for consolidation under Article 10 of the rules, none of the three hypotheses laid out by said article are met. Under Article 10A, the parties must have consented to consolidation. Respondent resists consolidation of the proceedings. Under Article 10B, all claims should be made under the same arbitration agreement. However, the new and the previous claims are not made under the same arbitration agreement. The new claim is made under appeal number 9601's arbitration agreement. Excuse me, 18604's arbitration agreement. Even if this arbitration tribunal should consider the circumstances of Article 10C of the rules on consolidation under multiple arbitration agreements, these are not met, which are that all claims pertain to the same parties, all claims share the same legal relationship, and that all arbitration agreements are compatible. It is undisputed that the claims are made between the same parties. However, the arbitration agreements are incompatible because it provided for a different number of arbitrators. Not only that, but there is no same legal relationship between the parties. According to ICC practice, there is only the same legal relationship between the parties when they have continuously traded the same or at least quite similar goods. However, the censors traded under appeal number A15-604 are not the same as the ones traded under appeal number 9601. The censors traded under the second PO also had a military purpose that the original censors traded under appeal number 9601 did not share. Therefore, there is no same legal relationship between the parties, and none of the requirements of Article 10 of the rules for consolidation are met in the current case. Not only that, but Article 10 of the rules also urges the arbitration tribunal to consider other relevant circumstances to the addition of an employment to consolidation proceedings. However, claimant could have introduced his new claim at the time that it requested the initiation of this arbitration. Payment under appeal number A15604 was due more than a year and a half before the signature of the terms of reference and over a year before the initiation of the arbitration. Not only that, but the consolidation of the proceedings may still lengthen the proceedings significantly, which should be avoided. In a nutshell, claimant wishes to cherry pick the rules elements to whatever best favors its requests. This cannot be granted by the arbitration tribunal. Thus, respondent requests the arbitration tribunal to deny claimant's pleas for the addition of a new claim and alternatively to deny his pleas for consolidation of the current proceedings with the second arbitration not yet initiated. Thank you.
Thank you. Before I pass the board on to Maria, can I just ask you, Anna, if you could elaborate a little bit more about the alleged incompatibility because of the number of arbitrations? That's something that was not clear to me. How your client deal with that? Is it an impediment? Is it a rule that the court, in case the parties do not reach an agreement, will definitely appoint a sole arbitrator? It's a recommendation. But it is mandatory. Could you please just elaborate a little more on this? So I think that would be good for Maria also to better respond to that.
Yes, Mr. Arbitrator, Article 12.2 of the rules does allow the court to appoint 3 arbitrators if it considers the dispute sufficiently complex. However, in about 80% of the cases analyzed under Article 12.2 of the rules in 2020, the court decided to appoint a sole arbitrator exactly because of its concerns with the efficiency of the proceedings. Some of the requirements considered when analyzing whether an arbitration is complex enough to be decided by 3 arbitrators, according to, once again, Thomas Webster and Michael Buehler, is the fact, for instance, if a state is one of the parties to the arbitration, and this requirement in the case at hand is not met. Therefore, the arbitration agreements are incompatible because the court is most likely to appoint a sole arbitrator to solve the disputes under appeal number A15604.
So it's just, for in your opinion, it's much more a matter of the use and custom rather than an mandatory requirement. See, the ICC court uses to do that. Is that your position?
Yes.
Okay. No, fine. Okay, good. That's like you're not here to say whether you're right or wrong. You're to understand your point.
I would like you to comment on the Article 9 of the rules, which says that claims based on separate contracts does not exclude their treatment as single arbitration. How do you think you did not approach this article in your explanation? In your view, you think they are incompatible?
Yes, because Article 9 of the rules still requires analysis under Article 6 of the rules. And Article 6.4.2, claims cannot be made under multiple arbitration agreements if the agreements are incompatible and if the parties have not consented to a unified determination of claims.
I have a question. You talked about efficiency, right? And I'd like to hear your view whether or not to consolidate wouldn't be more efficient for the parties to have a quicker and a more efficient and a less expensive solution for the cases.
As for the efficiency of the proceedings, if there is consolidation or even the addition of a new claim, Article 37.5 of the rules still establishes that whenever the amount of dispute is raised significantly, there will be a readjustment on costs. Therefore, the addition of a new claim or consolidation would still raise the advance on cost that has to be paid by the parties in the current case. Not only that, but Article 22.1 of the rules urges the arbitration tribunal to consider the efficiency of the proceedings both under cost and under time circumstances. Therefore, the addition should still not be granted nor consolidation.
And the last question, if I may. It caught my attention the fact that the only point of the case that you asked our attention to was paragraph 7 of the written statement of Alberto Duran. So if this is the only point that you draw our attention to, in my opinion, it's because it's something important to your client's position. Right? So, and it reads as follows. By that time, the new account manager for the LIDAR sensors finally got around to look at the unfinished old projects and realized that the second payment had not been effective. Is your client's position that in order for a claim to be accepted after execution of the terms of reference, it should be a justified reason because of a new fact or something? Why are you stressing so much the fact that it was, of course, a lose of attention by the party that didn't realize that payment had not been made? So is it again, you're not here to decide yet whether it's right or wrong, but is your client's position that the claimant would not have the right to require insertion of this new claim because it was their fault not to pay attention to that earlier? So contrario sensu, if claimant had a justifiable reason or something that could be reasonably justified, would the tribunal be allowed to accept the new claim? What's our client position as to the cause of the delay in asking the insertion of a claim?
Respondent has urged this arbitration tribunal to consider that there is no justification to delay insertion of the claim because in the ICC history, for instance, in ICC case number 21574, the arbitration tribunal considered the lack of justification to the addition of a new claim relatedly as a relevant circumstance to deny the addition of the claim. If I may quote, the arbitration tribunal stated, additionally, the tribunal finds no excuse, justification, or valid reason as to why Superior Columbia introduced the new claims only when filing its reply. Therefore, the arbitration tribunal should consider this as a relevant circumstance. However, even if it does not consider the related discovery as a relevant circumstance, then still the other requirements of Article 23.4 are not met, and this is why the additional claims to the claim is impossible.
Got it. Thank you. That's good. Thanks.
Any more questions? Okay. So please, if we can proceed.
Members of this tribunal, opposing counsel, once again, good morning. As previously introduced, my name is Maria Clara Schivani, and I'll be speaking on the procedural aspects of this case on behalf of Climate Sensor X. Within this presentation, members of this tribunal, claimants will mirror the same structure of arguments of respondents in order to demonstrate, first, that the new claim shall be admitted by this arbitral tribunal, and second, that consolidation shall be granted subsidiarily. Members of this tribunal, respondent started its presentation arguing that the claims the arbitral clauses are not compatible, and because of that, it would not be possible to admit the introduction of this new claim, since it is based on a different purchase order. However, in accordance with Article 9 of the ICC rules, a single arbitration can arise from more than one contract and arbitral clause, and it's of course required an analysis about compatibility. In accordance with the Secretariat Guide, members of this tribunal, there is compatibility in whether there is no significant differences or clear and inconciliated points between the both arbitral clauses, and there are no inconciliable points here. First, starting to the applicable law, the institutional rules, and the seats of arbitration that are also the same in both arbitral clauses. institutional rules are the ICC rules. The applicable law is the CISG, and the Nubian is the seat in both arbitrations. Regarding the point of the number of arbitrators brought out by opposing counsel, this is not an inconsiderable difference. They are different, and this is undisputed between the parties, but they are not incompatible. This is because while the first arbitral clause provides for 3 arbitrators, the second one provides for 1 or more, in such a way that it's possible to have this arbitration with 3 arbitrators, and one is more specific, 3 arbitrators, and the other is more general and provides for more than an option, in such a way that this is not incompatible. With this in mind, claimant submits that there is no incompatibility between the arbitral clauses, and therefore it can proceed to the analysis of the requirements under Article 23(4) to verify if addition of the new claim is possible in the present case, and its claimant's contention that it is. But before presenting the requirements under Article 23(4), claimant would respectfully request this tribunal to follow to page 55 of the case files, in which we have the terms of reference signed between the parties. Are the members understood? Okay. So here on paragraph 85, on the 4th line from the bottom to the top, starting with the arbitral tribunal, it states, the arbitral tribunal may have to consider, in particular, the issues listed in this paragraph, but not necessarily all of these or only this, and not necessarily in the following order. So, members of this tribunal, it's clearly stated here that the issues listed on the terms of reference are not exhaustive, and therefore a new claim can be added if the requirements on the Article 23(4) are fulfilled. And the requirements under Article 23(4) are 3, and that shall be evaluated by the arbitral tribunal. First, the nature of the claimants. Second, the stage of the arbitration. And lastly, any other requirements this arbitral tribunal considered to be relevant. Claimant will now demonstrate that all these requirements point towards the acceptance of the new claim.
Sorry, Ms. Maria, can I just ask you something, just to get the point here? Do you treat it differently, incompatibility and impossibility, or do you use both as synonyms? Because something may be incompatible, but concealable, or because you use the both terms. They're right terms. I don't know how to spell it properly myself, but you mentioned that. Do you treat those as the same thing, or there is a slight difference?
Mr. Arbitrator, in accordance with the Secretariat's Guide to the ICC rules, it will exist an incompatibility when there is both a difference and an inconceivable. So that it must have both to have an incompatibility between the arbitral clauses.
Okay, so the 2 elements.
Yes.
Got it. Thank you. Sorry for the interruption.
No problem. So starting with the first requirement under Article 23(4), which is the nature of the claims. In accordance with Professor Scheffer, the test to be made here is one of connection and similarity between the claims. And here we have this connection between the claims since both arise from the same scope of the framework agreement, which establishes the general provisions of sale. Also, opposing counsel stated that the test would be of a contractual discussion. This contractual discussion is the same in both cases, and it is on the present case. This is because both claims would discuss the possibility to amend specifically Article 40 of the framework agreement. On the first claim, there was a discussion that will be more explained by my co-counsel about the possibility of amending the bank account provision of the framework agreement by email and without following the formal requirements of Article 40 of the framework agreement. On the second claim, on its turn, there will also be this discussion since the parties did the notice of defect without fulfilling these requirements and respondents argued that It was a difference, a modification on the Article 15 of the framework agreement. So both claims discuss the same contractual clause in such a way that it's more efficient to admit it here, since it could use the same contractual interpretation and decide both claims altogether. With this in mind, claimant submits that this requirement under Article 23.4 was fulfilled and that the nature of the claims went towards its acceptance. Regarding the second point under Article 23.4, which is the stage of the arbitration. Claimant submits here that this arbitration is still at an early stage, since the terms of reference were signed only 11 days before the presentation of this new claim, and therefore most of the procedural steps had not yet been concluded before the presentation of this new claim. As for the argument of opposing counsel, that claimants could have brought this claim earlier, and therefore it's not the new claim shall not be admitted here. Members of this tribunal, this is not a problem since the arbitration is still at an early stage. In accordance with Professor Baylor on its commentary to the ICC rules, it states, and I quote, "There is no reason not to admit the new claim, even if it could have been made earlier if the proceedings are on an early stage." Also, as for the ICC case mentioned by opposing counsel, on that case, the rationale was that because the proceedings were already on a late stage, there were already existing the hearings of the arbitration in such a way that claimants could have, that their party could have brought the claim before, and there is a late stage. Here, we have an early stage that allows the claimant to introduce this new claim. In this regard, claimant admits that the requirements of stage of arbitration was also fulfilled under Article 23.4, and therefore the addition of the new claim shall be granted. However, members of the tribunal, if the arbitrators understand that it shall not admit the introduction of the new claim, it shall at least consider the possibility of consolidating both arbitrations. Members of this tribunal, respondents argued, and I quote, that this arbitral tribunal does not have enough power to judge consolidation in accordance with Article 10 of the ICC rules that provides this power to the ICC courts. For the sake of clarity, claimant does not contest the existence of Article 10. What claimant does contest is its applicability to the present case. And this is because the parties have agreed differently on the framework agreement. In this regard, if the members of this tribunal could kindly follow me to page 12 of the case files, in which we have the arbitration agreement of the framework agreement. Are the members of this tribunal with me?
Yeah.
So here on paragraph 5, it states on the second line from the bottom to the top, starting with the arbitral tribunal. The arbitral tribunal of the first arbitration proceedings has the power to consolidate all such proceedings into a single arbitral proceedings. Members of this tribunal, this provision of the framework agreement is enough to derogate ICC court's competence in the present case. And this is because the party's autonomy is a cornerstone of ICC of each of any arbitration and provides power to the parties to modify the institutional rules. In fact, this was already done before on ICC case 16-982. On that case, the parties argued for the parties on the arbitral clause provides for consolidation on the to the arbitral tribunal, such as in the present case. And on that case, the arbitral tribunal considered that it has enough power to judge consolidation. So this case shows, members of this tribunal, that the ICC does not have a problem with arbitral tribunals judging consolidation, and therefore, this arbitral tribunal has enough competence to judge consolidation. As for the requirements under Article 41.5, opposing counsel stated that there are two requirements to be fulfilled here. First, the risk of conflicting awards, and second, the existence of common questions of fact and law. Starting with the first one, there is the risk of conflicting awards. opposing counsel brought out that it will only exist the risk of conflicting awards, and I quote, if the decisions are mutually exclusive. Members of the tribunal, this is for sure one side of conflicting decisions, but that is not the only way in the way there could be risk of conflicting awards. In fact, in accordance with Professor Pierre Meyer on its book about conflicting decisions, there could be a risk of conflicting awards if the rationales and the clause interpretations of the contracts are made on different ways from different arbitral tribunals. And this could happen on the present case, as both claims would deal with the question of Article 40 of the ICC rules, and one arbitral tribunal may, for example, admit that an email is enough to change a provision on the framework agreement, and the other one provides that there is necessary to fulfill all the requirements under Article 40. So this would create a risk of conflicting awards. As for the other requirements, that is the existence of common questions of facts and law, this exists in the present case. Says first, there is the same contract that governs the general provisions, which is the framework agreement. Second, both contracts are related to the very same contract, to the very same clause, and will deal with the non-payment issues. So here, there is this common questions of facts and law. As per the requirements under Article 10 of the ICC rules, the requirements under the scenario under Article 10C is fulfilled. And under Article 10C, consolidation shall be granted if there is common questions of facts and law, and if the arbitral clauses are compatible, which were all proven by claimants in the present case. With this in mind, claimants admit that this arbitral tribunal can and should grant consolidation to the arbitral proceedings. Members of this tribunal, claimants admit, first, that the new claim shall be admitted by this arbitral tribunal, and second, and subsidiarily, that consolidation shall be granted. Thank you.
Well, as I mentioned earlier to your colleague, the tribunal is particularly interested in arguments when the counsel drives our attention to some specific point of the case. Remember that. So you draw our attention to page 12. And just emphasized the sentence, the arbitral tribunal of the first arbitration proceedings has the power to consolidate all such proceedings into a single arbitral proceeding. If we read the whole paragraph, we see that is the risk of conflicting awards is an important element in order to get the final conclusion that you selected to read for us. I know that we have already ruled that this moment is not appropriate to discuss the merits of the possible second claim. But we all know that the second claim has to do with the quality of the censors, while the first claim has to do with a wrong payment or a payment made to a wrong account. What's the risk of conflicting awards in this?
Mr. Arbitrator, it's claimant's contention that here it will not discuss it if the product or even had the defect or not, but rather if respondent fulfilled the requirements to produce a notice of defect and to evaluate and to warn claimants about this issue of the defect. So here it will be a conflicting decision, since both claims will discuss the formal requirements. It will discuss in both claims if it's possible to just by email send like a notice of defect or even change the bank account. So this would cause a conflicting decision, as it will probably be a risk of different interpretations of the contractual clauses.
Thank you.
Just again, going back to terms of efficiency, time and efficiency. So we know that this would be probably a first decision to be made in both claims, as you allege, about the method of changing the contractual obligations. But afterwards, we're gonna have probably discussions on different technical matters. Do you think it's gonna be efficient for the parties to have those discussions that are so different within the same procedure?
Indeed, Madam Arbitrator, claimant submits that it would be efficient for two reasons. First, because it will be cheaper to deal with both claims on the same arbitration, since in accordance with calc made on the ICC cost calculator, to have different arbitrations, it will be an initial cost of $700,000 approximately. And having all the arbitrations together here, it will be a cost of $600,000. So it's a saving of $100,000. That would be a cost efficiency and a noticeable save of costs. Regarding the time and this type of efficiency, it will also be efficient since it will be possible to use the same set of circumstances, the same set of analysis, and to use the interpretation of the framework agreements only once, since this arbitral tribunal will already need to interpret the framework agreement, specifically Article 40. It's going to use the same interpretation to resolve both claims at almost the same time.
Thank you.
You talking about decision of efficiency, you emphasize that the early stage of the arbitration is a very important consideration that we have to make. And you base this earliness requisite on a professor, on an author that you mentioned to us. I can't remember his name, but anyway.
It's Professor Dale.
Okay, yeah, great man, great author. But what else? What does the earliness of the proceedings arise from the rules or the law?
Mr. Arbitrator, it would be this early is important because, for example, if the proceedings were already at the hearings, it would be more difficult to admit this new claim, since it will be necessary to reopen all the previous stages in order to guarantee the right of defense of the counterparty, which is a basic principle of any procedure specific on arbitration. And since we are on a normal stage, this would not be a problem, as the parties have not even presented it on the moment of the submission of the new claim. The parties have not even presented its written phases, its written memorials, and stuff like that.
No, I get your point, and I understand the practical reasons for that. What I'm asking is the moment of arbitration, being early or late. Does it come from a common sense? Because of course, the earlier, the better in terms of saving money. Or do you find this principle in any part of the ICC rules or anywhere else besides doctrine, besides authors' opinions?
Mr. Arbitrator, the law is drawn on the moment of the fact that the parties can present a new or even still present their defenses or not. But in this moment, I do not have a provision on the ICC rules to present to your members of the tribunal, but I could provide it later on the moment of the written phases for conclusion.
Okay, thank you. Fair enough.
Second chance, second round. So please, yeah.
Members of this arbitration tribunal, respondent does not contest the importance of party autonomy to an arbitration. However, changes agreed on between the parties, later questioned by one of the parties, cannot oblige tribunals to disregard what the institutional rules have established. Even past decisions by the ICC do not bind this arbitration tribunal's decisions, and Article 19 of the rules should still be taken into account. Therefore, claimant's request for the consolidation of the proceedings cannot be granted. Thank you.
Thank you. Members of this tribunal, claimant is not contesting the role of the ICC rules by no means, but what is stating is that the parties have agreed differently, and in fact, it was respondent who insisted on this consolidation option on the framework agreement. So it cannot now contradict its own requirements to provide for consolidation by the court, since in the very first moment, it agreed with consolidation by the arbitral tribunal. Thank you.
Okay.
I have a question. I would like to hear the respondent regarding the applicability of the framework agreement. You didn't mention this issue in your exposition. I would like you to comment on that.
So, according to ICC scholar Philippe Boulanger, whenever the parties have drafted an arbitration agreement and included a dispute resolution clause in this agreement, but later in a series of purchase orders have included different dispute resolution clauses, and they have agreed to modify the original arbitration agreement. Therefore, this arbitration tribunal should not consider the framework agreement's arbitration agreement as the one that encompasses all claims in this arbitration.
Would you agree with that?
Mr. Arbitrator, claimant begs to differ, says in the own purchase orders, it stated that the framework agreement applies in everything that is not agreed otherwise. So the arbitral clauses here are connected and they complete itself. For example, the arbitral clause of the framework agreement is much more complete than the arbitral clauses of the framework of the purchase orders. So they must be analyzed as a whole and not individually and separately.
Two strong positions. Well done, thank you. Are you ready to go to the merits?
Ready.
É meio tricky, né? As garrafinhas bem bonita, design bonito, mas tem que tomar cuidado. De mal educada, né? Vem na casa dos outros. Né?
Eu ia falar isso agora, está reclamando.
Eu queria mexer. Você deu abertura, né? Let's move to the merits.
Yes, please.
Thank you, Madam Presiding Arbitrator. Once again, good morning to all members of the Subject Tribunal, esteemed opposing counsel. My name is Gabriel Figueiredo, and I'll be representing Censor X PLC, the claimant in the present procedure, on the merits of the case. Members of the Subject Tribunal, sunlight is said to be the best of disinfectants, since shedding light on dubious facts is key to understanding any dispute. The present case is no different. By analyzing the actions of both parties, it shall become clear throughout this presentation that first, respondent is not entitled to the exemption of payment under purchase order number 9601. And second, respondents cannot invoke a violation of a duty to inform to request any price reduction for such payment. Now coming to claimant's first submission, members tribunal, the present issue arose because respondents received a suspicious email from cyber criminals who were requesting a bank account notification for the payments of the purchase order just mentioned. However, even though there were red signs in this email, respondents, without further investigating the message, still sent the amount to the cyber criminals instead of claimant, and that is why we're here discussing this matter today. Now, it is important to understand to this first issue, Article 80 of the CISG, which might be brought by the opposing counsel as to the exemption of this payment. Now, members of the tribunal, Article 80 clearly states that for a party who was a failure to perform such obligation must have a causal link and a direct and objective connection between one party's action and the other's failure to perform. And here, members of the tribunal, what we have here is that in this Article 80 and in the present situation of this case, we do have some facts to be highlighted. And before moving to the facts of the case itself, claimant would like to present to the Arbitral Tribunal a case law, which establishes in a very clear way that in this case, which is very similar to the one that we're going to present, which has to do with failure to perform and also a cyber attack. This case was judged in 2023 by the Estonian court, which is called the poultry case. And members of the tribunal, here we have an analysis about the causal link between a cyber attack and the failure to perform such obligation, which is the same here we're talking about, payment. I would like to quote one part of the decision for the Arbitral Tribunal, and I quote, "No conclusive evidence has been provided in the proceedings as to which of the parties failed to exercise due diligence to protect their data and cause the situation." End of quote. And here, members of the tribunal, we have that, of course, claimant had a cyber attack. This is incontested. However, what we're dealing with here is whether the cyber attack has been the direct cause of the phishing attack being successful. And here we have to analyze two different things. First of all, if had informed respondent, would respondent still fall for the same phishing attack? And this is not proven, and there's still no evidence that can provide such causal link. And secondly, if the email was indeed suspicious, then respondent should have seen all the details within the email, which I'm going to present now to the Disaster Tribunal. So therefore, I would like to ask you to follow me to page 16 of the case files. That is claimant exhibit C5, excuse me. That is the email sent by the cyber criminals to Mr. Royce, respondent's account manager. This tribunal with me? So first of all, members tribunal, I would like to highlight, first of all, that the origin of the email could have been easily identified. And even though here we're talking about one letter of difference, since we can see here the domain is written CensorX with an M, and in the very bottom part of the same email, it's written CensorX with an N. Of course, it is presumable that this is not a big difference, of course. However, what it seems like here is that when we choose one small letter, it changes everything. This is because, for an example, if you have a postal code sent to Alaska, if you change one simple number, it might be sent to California instead. So here, what we have is that we have this very important detail which could have been easily identified by a respondent. Secondly, members of this tribunal, we have also that the bank account details are modified here, as you can see in the very middle part of this document. This bank account in specific is not listed in the framework agreement. And just to be clear, in the framework agreement, there is a list of all the bank accounts to which the payment should be forwarded to. And of course, to all contracts, there also are amendments for sure. However, here the amendments are ruled by Article 40 of the same framework agreement, which requires two different criteria for any amendments to be correct or to be valid. First of all, it needs to be in writing, which is not disputed here since an email is in writing. However, it also needs to bear signatures from both parties, which is nowhere to be seen here in this present email. So therefore, the document here could not also be seen as a practice between the parties, since it was also violating on Article 40 of the framework agreement. And third, members of the tribunal, we have an inconsistency with the content itself. If this tribunal could please follow me to the second paragraph from the bottom to the top, starting with "could you thus." This tribunal with me? I would like to quote the following. "Could you thus please urgently change the banking details and then immediately confirm such change by replying to this email so they can authorize shipment." End of quote. An important part here, members of the tribunal, even though there are underlying words here, the important part is that the authorization of shipment is inconsistent with the order of the own purchase order, because the negotiations were established the following order. So first, we would have that we have the payment, the shipment of the goods, and only 1 month afterwards, we have the deadline for the payment. So here, under the urgency of changing the bank account details, would only be 1 month after the goods were received. So therefore here, we could also have a different analysis of this, because you shouldn't have any urgency here, in special when it's consistent of authorization of shipment, which had already been previously established before between the parties, which was already authorized. Now, members of this tribunal, there is also one other important factor to be analyzed in the case as a whole, beyond the email itself, which is the knowledge of the market. Here we have that within the automotive industry, there was a well-known knowledge of all the players in the market that they had cyber insecurity issues within all top tier 1 and 2 of the automotive industry. And here, respondents themselves have also been a target of phishing attacks in the past, and therefore also should have known of these attacks and also what entails to have it here. And in order to demonstrate that how they standard within your knowledge in the market, I would like to present to the Disaster Tribunal another case law called the dry top case. In this case, members of the tribunal, we have that one buyer and a seller had a contractual relationship, and that the seller was not able to fulfill its obligations due to the fluctuations of this own market, which was the pine kernel market, in a sense. And here, members of the tribunal, there was a delay with the delivery, and therefore the seller was not able to fulfill its obligations. And the line which should be drawn between this case and the present case is the fact that the knowledge of the market here was essential for this performance to be executed. And in the case law at hand, it was that the court decided that which we should have a market knowledge by the seller, which would enable them to perform the obligation in the first place. And here, by having such knowledge, which respondent most certainly had, due to the fact that it was known in the automotive industry with the media, and also because respondent has previously been a target, it is crucial to understand that this market knowledge would also be very important for respondent to identify this phishing attack as such, mainly considering the signs that I just pointed out in the email itself. Then, members of the tribunal, it is claimant's contention that a respondent could not be entitled under this exemption because of a lack of a causal link between the cyber attack and the successfulness of this email with these many red signs, and also considering the knowledge of the market. Now coming to claimant's second submission is that respondent cannot invoke a violation of a duty to inform to request a price reduction. And here, members of this arbitral tribunal, we're going to be dealing specifically with Article 77 of the CISG. And it is certain that Article 77 of this convention is under the chapter of damages, which is not what we're discussing here today, since we're discussing performance of the payment. However, what a respondent might allege is that there are indeed duty to inform within the CISG by principles. And specific here, we could acknowledge, for example, the principle of prevention, which underlines Article 77. And it's not claimant's contention here, members of the arbitral tribunal, that there is no duty to inform or duty to cooperate or any duty to mitigate any losses. What claimant is arguing here is that claimant did the best actions at the time under the circumstances in which happened. In order to demonstrate that, I would like to draw a timeline for this arbitral tribunal due to the fact that claimant did the actions at the time they were given, and therefore the reasonable measures were taken by claimant. So first of all, there was the minor incident of the cyber attack in January 5th. And on this day, members of the tribunal, claimant hired previously the CyberSac, which is the best cybersecurity company in Ecuadoriana, who provided the feedback that there was a minor relevance attack and therefore there's nothing to be worried about. Now, afterwards, in May, there was a confirmation that there was indeed other malwares that were infiltrated in claimant's internal system, and the first action of claimant was to shut down the whole IT system so that no information could be gotten by the cyber criminals. So here we have, first of all, the first measure, there is no duty to inform, firstly, because it was initially of minor relevance. Secondly, we have an action of shutting down the IT system in order not to have any data leak. And therefore, the duty to inform here, members of the tribunal, was not fulfilled, but there were other actions by claimant which confirms that they were trying to mitigate the loss in the best of their circumstances. And lastly, in order to understand why claimant was such in a difficult situation, was because they were asking also from the cyber criminals a ransom, whether for they were being blackmailed for the information of the clients. And here, members of the arbitral tribunal, is a very tough spot for any companies, because here you're dealing with all the information that could have been gotten within this cyber attack. And here, the mitigation of the loss within claimant's actions was to look at the whole picture and try to contain all the possible consequences that this ransom could have gotten to all the parties, in the sense, all the clients that claimant has. So here, of course, there is not this direct information from claimant to respondent, it is a fact. However, here, we need to analyze the circumstances under which claimant was directing all the efforts in order to protect information from all clients and not only respondent. So here, members of the tribunal, what we have is the reasonable measures within this situation were being taken by the time the claimant was receiving all such information from, again, CyberSec, which was the best cybersecurity in Ecuadoriana. So there was no reason also to doubt that the best cybersecurity in Ecuadoriana would not do their job well. So here, at claimant, as not an expert in the cybersecurity business, just believed the best there is, and therefore it did all it could in the circumstances in which it was put in the present case. Now, members of the tribunal, it is not reasonable now that claimant would request such price reduction under Article 77 due to the fact that the reasonable measures were indeed taken under the circumstances in which claimant was in. And in light of the exposed, claimant would like to request as Dr. Tribunal that first, respondent is not entitled to the exemption of payment under Article 80. And second, respondent cannot invoke a violation of a duty to inform or any other duty to cooperate within the CSG or any other legal matters to request a price reduction in this sense due to the reasonable measures which were taken in the present case. Thank you.
Thank you.
I have one question to begin. Sure, there's gonna be a lot of questions. But first one, even after the shutdown of your IT system, of your client's IT system in May 15, your client did not inform the respondent about the cyber attack. Even after that, when your client were aware of the magnitude of the attack. And don't you think that you have, after the shutdown, the duty to inform? I would like you to comment on that.
Mr. Arbitrator, first of all, after all these circumstances, also, there is yet another one that I did not mention, which is that there was an internal order from claimant to all the account managers to inform all its counterparts. So here we would have a sick leave from Ms. Audi, which was unavailable, and therefore her substitute, which was Ms. Pedro, she was also out of office due to pregnancy complications. So then they did not have the personnel to inform. However, the order was sent out, and therefore there was this intention to inform. However, for all the situation that I've just explained, they could not have also focused on replacing the personnel in order to send this email.
How would you legally characterize this fact as an exemption of responsibility? It's a force majeure, it's an act of God, because she was God to deal with her pregnancy. What's the legal framework to use that as an exemption of responsibility?
Well, Mr. Arbitrator, we have here, a lot of different circumstances, but what we do acquire here is that this whole set of circumstances would fall within a hardship situation, for example. There's the fact here that not only one or the other, but many things simultaneously were happening in this case. So we're not talking about here only the pregnancy complications or the sick leave or only the blackmail. We're talking about them all together, which configures a different circumstance that shall be taken into consideration by the Arbitral Tribunal when analyzing such matter.
Thanks.
Nothing for now. So, can we proceed?
Yes. Honorable members of this tribunal, esteemed colleagues, good morning. As previously presented, my name is Jada Mark, and on behalf of respondent, I'll address the merits of this dispute. Members of this tribunal, throughout the procedural issues, we have already heard how claimant's internal problems have led it to request the belated inclusion of a new claim. Now, once again, claimant's ineffective business organization is the reason for its request for payment. Members of this tribunal, claimant uses these proceedings as a way to avoid the consequences of reckless behavior. Such an attempt must be declared unsuccessful. In the course of my submission, I shall demonstrate that first, respondent has no payment obligation for the censor's order under purchase order number 9601, and alternatively, that the obligation must be reduced. Members of this tribunal, this is not the first cyber attack that affects the parties' relationship. In 2020, respondent also was the subject of a cyber attack. Considering the good business practice and the long-term relationship established with claimant, it immediately informed it of the cyber attack. At the time, claimant was respondent's most concerned partner and required to be immediately informed if any data relating to his company had been obtained by the cyber criminals. However, in 2022, when claimant suffered a cyber attack, he did not demonstrate the same concern for respondent's information. Rather, he decided to remain silent and not inform it of this incident. However, contrary to the cyber attack suffered by respondent in 2020, the cyber attack suffered by claimant in 2022 was much more serious and allowed cyber criminals to access relevant information of the parties' relationship. Using this information, the cyber attackers were able to send an email requesting the alteration of claimant's payment method. By paying to the new bank account, respondent has performed his obligation. On May 3rd, 2022, respondent transferred $19 million to the new bank account. No complaint was heard from claimant. Again, on June 30, 2022, respondent transferred another $19 million to the same bank account. Only in September, claimant alleged that there was a missing payment. However, respondent has performed his obligation and cannot be forced to pay a second time. Members of this tribunal, the counterparty has argued that respondent cannot be exempted under Article 8 of the CISG. It has pointed out the two conditions that must be analyzed in order for a party to be exempted due to the other party's omission. First, it is necessary that the party is under a duty to perform the omitted act. And second, it is necessary that there is a causal link between the omission and the non-performance. In the present case, both conditions are met. First, because there is no scenario where a claimant could have chosen to remain silent and not inform respondent about the cyber attack. This obligation can be deduced from the parties' relationship and from the laws applicable to the matter. First, because as the parties had previously conducted themselves in a similar situation, it was claimant's obligation to inform respondent considering the practice that had been previously addressed. In this sense, according to legal scholar Ingbor-Schwenzer, one-time events can suffice to establish a practice if the conduct is of such importance to the parties that it can reasonably be assumed to have envisaged the same conduct to be displayed also in similar circumstances in the future. Considering the importance of this information to the parties' relationship and to the performance of the contract, claimant was under a duty to inform respondent about the cyber attack as respondent had previously done in a similar occasion. Also, the claimant was under a duty to inform respondent considering the law applicable to the matter, that is, the CISG. First, because under the CISG, one of the general principles that guide the convention is the principle of good faith. As recognized by legal scholars such as Stephen Kroll, Lucas Mistelis, and Pilar Viscasillas, the better view is that the principle of good faith permeates the whole text of the convention, deriving from it specific duties and rights to the parties. One of the main obligations that stems from the good faith principle is the duty to communicate the other party of relevant information that might affect the party's relationship. In the present case, it was evident that the information about the cyber attack was important to the parties. And this has been recognized by my counterparty, as it has mentioned that there was an internal order within claimant's company to inform its partners. Therefore, claimant has recognized the need to inform its partners about the cyber attack, considering the relevant consequences that could be caused by this event. However, it has only failed to inform respondent due to a general shortage of personnel. Members of this tribunal, respondent cannot bear the burdens for claimant's internal problems. It was under a duty to inform respondent about the cyber attack and has only failed to do so because of its ineffective business organization. Also, even if it is considered that the CISG does not provide a duty of information in the present case, it is necessary to also analyze the Danubian Contract Act, the law applicable to the domestic law chosen by the parties. In this sense, according to Article 5.1.3 of the Danubian Contract Act, the parties are under an obligation to cooperate between themselves in order to guarantee the performance of the contract. In this sense, according to legal scholar Stefan Vogenauer, it is reasonable to expect a party to share peculiar and highly relevant information that is, in the circumstances of a case not accessible to the other party. The stronger the information asymmetry, the more reasonable it is to expect the cooperation of the party that possesses the knowledge. Members of the tribunal, in the present case, not only was the information about the cyber attack highly relevant to respondent and to claimant's partners as it has itself recognized, but it was also not easily accessible to respondent, considering that this was an information that was only obtained by claimant. Therefore, there is no scenario where claimant could have chosen to not inform respondent. Not only that, but this was the cause for respondent's non-performance in the present case, which allows it to be exempted under Article 8 of the CSG. Members of this tribunal, contrary to what my counterparty has argued, Article 80 does not provide any test of causation in order to establish an exemption to the party due to the other party's omission. This is recognized by legal scholars such as Stephen Kroll, according to which the only requirement that the breach must be a consequence of the behavior of the other party. In this sense, according to also legal scholar Thomas Newman and the duty to cooperate in international sales, the scope of the role of Article 8 in the CSG, no particular test of causation has to be applied when establishing a link between the promisor's non-performance and the promisee. Rather, it is seen that any conduct in the specific circumstances may be relevant under Article 80 as long as it is possible to establish a connection. This has also been recognized by other cases that apply Article 80. For example, in the propane case, even though there was no direct causation for the non-performance of the other party, it was understood that the party was exempted due to the other party's interference with non-performance. In the present case, such a connection between the claimant's omission and respondent's payment to the wrong bank account is evident. First, because if claimant had informed respondent about the cyber attack, respondent would not have trusted any electronic communication that was sent by claimant. Not only that, but if claimant had informed respondent that the first installment had not been received, respondent would not have proceeded with the second installment due under purchase order number 9601. It is evident, therefore, that the only reason for respondent's payment to the new bank account was claimant's conduct, and therefore it must be exempted from performance. Also, contrary to what my counterparty has argued, it was reasonable for respondent to interpret the email as a statement made by claimant. First, because the email contained detailed information of the parties' relationship that only claimant had access to. For example, it mentioned the size of the orders, payment formalities, and delivery dates that only claimant could have had access to. Also, even though the email contains typing errors, it must be considered the fact that the parties had previously committed such mistakes in their communications. For example, in the email sent by claimant in a previous situation, it had also spelled Censor X with an R, that is, Censor X. The framework agreement itself provides the name of the company Censor X with an M. It was reasonable, therefore, for respondent to interpret the email, even though it contained typing mistakes, as an information provided by claimant. Well, contrary to my counterparty, even though Article 40 of the framework agreement provides that amendments could be only made in writing and with the party's signature, in the present case, it was completely reasonable for respondent to interpret the email as a valid amendment of the framework agreement. Under Article 29(2) of the CSG, where the party's conduct indicated that amendments could be made in this regard to the form requirement previously agreed, the parties will be precluded from invoking such restrictions after their conduct. In the present case, the parties have previously conducted themselves in order to indicate that amendments could be made despite the form requirement set forth under Article 40. For example, the framework agreement, it provides that the price fixing should occur semi-annually. Later, during a meeting, the parties had decided to establish the price fixing annually. This was not written and was not signed by the parties. Also, the framework agreement provides that respondent was entitled to order up to 800,000 sensors per quarter. With its purchase order number 9601, respondent has ordered 1.2 million sensors. Also, in the framework agreement, it is provided that payments should be made 15 days after delivery. With its purchase order number 9601, payment was to be established 30 days after delivery. The purchase order was sent via email and did not contain the party signature. Members of this tribunal, it was completely reasonable for respondent to page the new bank account. Therefore, it must be considered that respondent cannot pay a second time. However, if it is considered that respondent cannot be completely exempted from performance, respondent must be at least partially exempted from performance. Considering the principles underlying Article 7.7 of the CISG. This has been recognized by a German Court of Appeals in a case involving the claim for sorting potatoes. On the occasion, the court reasoned that an allocation according to each party's causation would be possible due to general principles underlying Article 7.7 of the CISG. On that occasion, it was also understood that the party was under a duty to inform the other party of relevant information for the performance of the contract. And therefore, in the present scenario, it is also necessary to consider claimant's admission about the cyber attack and about the missing payment of the first transfer in order to consider that it has affected respondent's performance, and if it cannot be completely exempted, then it must be at least partially exempted from performance, as it has not acted with the necessary good faith for the party's performance of the contract. Members of this tribunal, respondent cannot be forced to pay a second time due to claimant's reckless conduct. In conclusion, respondent respectfully submits that first, it cannot be forced to pay a second time and has no payment obligation for the sensors ordered under purchase order number 9601, as it was reasonable for it to pay to the new bank account, and the failure to pay to the bank account provided by the framework agreement only occurred because of claimant's omission of relevant circumstances and that allows respondent to be exempted from performance. And alternatively, if respondent cannot be completely exempted from performance, it must be at least partially exempted, considering the principles underlying Article 7.7 of the CISG, so that causation is allocated to each party's contribution to the non-performance. Thank you.
It's perfect.
Congratulations.
You mentioned, Julia, the Danubian law, just a local law that has been elected by the party, the Contract Act. And you mentioned the principle and the duty of cooperation, right? And based on this duty of cooperation, also the modern interpretation of the duty to inform, that is, of course, the duty to be informed. So it's more and more understood that the duty that the party has to inform the other one is reciprocated by the duty to be informed, or the duty of curiosity, the duty of trying to know what's going on. Based on that, while I was listening to your presentation, it occurred to me that two things should be addressed. One is the inconsistencies of the email that you mentioned. And I understand from your position that it was typos or something that had happened before. I'd like you just to elaborate a little bit more on this. Why this would exempt your clients to be at least curious about, well, it sounds different. And the other thing is the knowledge of cyber attacks at the time in this market. The conjugation of these 2 points, I'm not saying, I'm not prejudging, please, but the conjugation of these 2 points seems to be relevant to maybe exempt respondent in this case from this duty to be informed. So the putting both together, the consistencies in the email and the knowledge of cyber attacks around the world at the time, Could you please just elaborate a little bit more on the conjugation of these 2 points in order to convince me that this would release your client from this duty to be informed?
Yes, Mr. Arbitrator, if you may have the time, additional time to answer your questions. Regarding respondent's duty to be informed, I will mention a case also under the CSG where it was decided that it would contradict the principle of good faith, international trade, as well as the general obligations of cooperation and information of the parties to impose on the other party an obligation to inquire concerning information that had not been transmitted and to burden him with the risks and disadvantages of the unknown situation. Also, it must be considered that under Article 80 of the CSG, the obliger is not under a duty to overcome the impediments caused by the other party. This is recognized by legal scholars such as Igor Schwenzer and Stefan Pro. In the present case, therefore, even though respondent could have noticed the alterations in the email, it was not under a duty to overcome this impediment. It was under claimant's duty to inform respondent and has failed to do so. Also, it must be considered that it was reasonable for respondent to interpret the email despite the existence of spelling mistakes, considering that the parties have previously incurred in such spelling typos. For example, in page 34 of the records, in the email sent by claimant in 2020, in the signature of claimant's head of sale and purchase, the email was also spelled incorrectly.
What was this email about? An order of payment, change of a bank? Was that serious? Sorry.
No, Mr. Arbitrator, it was not about like this page 34. It was not about the alteration of the payment. However, this was the email sent by claimant after it respondent informed it about the cyber attack. If this arbitral tribunal look at the email, we can see that in the first phrase, we can already see that the claimant informed that it greatly appreciated your open and forward-looking communication concerning the cyber attack on Visionic. Not only that, but in the 5th paragraph, it also mentions that naturally, we're required to be kept assured about your investigation and to be informed immediately should data relating to us and our people have been obtained by the cyber criminals. Members of the tribunal, claimant's conduct contradicts its previous behavior in a similar situation and respondent must be exempted from performance.
What about the knowledge of cyber attacks you include in this request that your client made?
Yes, Mr. Arbitrator, concerning the knowledge in the industry, it must be taken into account the fact that the article published by Automotive Weekly was published on May 20, 2022. Respondent transferred the purchase price on May 3rd, 2022. That is almost a month before the publication of the article. And it was therefore not expected to know about this. And even though it was aware of this incident, it was claimant's duty to inform it about information that occurred within his company, not respondent to search this information through articles or through other means.
Thank you. Appreciate that. Thanks.
One question. You mentioned that the proof of mail would be an amendment to the contract. And I would like to hear from you about the form requirements of the Article 40 for amendments in the contract. Would include the requirements, these emails?
The email regarding the written requirement, it does fulfill such requirement as it is understood and electronic communication can be understood under the CSG as a written form of amendment. But even though it does not contain the party signature, it must be understood that the parties had previously deviated from such requirement. And according to Article 29(2) of the CSG, where the parties' conduct indicated that amendments could be made in this regard to the form requirement, the parties will be precluded from invoking such restrictions. And therefore, claimant cannot now invoke Article 40 to argue that the email was not a valid amendment.
Yeah.
Thank you. Well, members of the tribunal, respondent states that an amendment by email would be usual. However, what respondent has admitted is that previously, the only one time that a bank account modification has been made, it was made through a signed letter. And therefore, it cannot now contradict itself and say that this was a usual practice between the parties. Thank you.
I have a question. But do you confirm that in other occasions, the parties have changed the contract without signature? And how do you explain that within this circumstance?
Well, Madam Arbitrator, there is one fact that must be clarified here. There was a price fixing meeting that was indeed sent by email, and therefore there was no signatures on it. However, the circumstances are quite different. This is because there was the minutes of the board meetings which were in person. So therefore, here we would have a debate which was paid in person, which exactly knows where the information is coming from, and therefore the minutes of the emails were just to formalize the discussions made in person. Therefore, we could identify who was the one making the arguments and changing the amendments to the contract.
Members of this tribunal, claimant tries to ignore the party's previous practice. First, by arguing that amendments could not be made in other forms that did not follow Article 40. And second, by completely ignoring the previous conduct that it has adopted when a cyber attack was suffered by respondent. It was under duty to inform it about such relevant circumstances, and its failure to do so is the reason for respondent's payment to a different bank account. Respondent therefore cannot pay the second time. Thank you.
Thank you all.
Thank you.
Congratulations.
Thank you.
Só vou tirar o tiro fora. Gabriel, ele pode. Vou levar para o chão. Ele pode ser encarado.
Ah, sim.
Beijo.
Chega a hora, não aparece.
Faz o Lucas aqui.
Pois é, né? Papai Noel. Papai Noel.
Aliás, só viu o Lucas aqui.
É que eu tô logada na conta dele.
Eu sei também. Falar, Lucas, pode ser amanhã com você.
É que ele não pode se afastar lá da filhota dele.
Verdade. Obrigado, gente.
Obrigado.
Boa tarde, na reta final. Queria primeiro agradecer a participação dos times, dos coaches, especialmente, fazer um trabalho, às vezes, silencioso, bastidor, dos membros da equipe. O tribunal arbitral, tanto os árbitros da final, quanto todos os árbitros que participaram desses últimos 2 dias. É a 12ª edição do Rio Pre Moot, que nos dá muito orgulho. Muito difícil no Brasil as coisas terem continuidade, mas eu acho que o Bismut e o Rio Pre Moot é uma dessas coisas. Queria agradecer, em primeiro lugar, ao CBMA, que nos hospeda já há algum tempo. CBMA.
Não sei coisa que não apareceu. Para reforçar.
Você hospeda tanto tempo, uma estrutura maravilhosa, é um luxo poder contar com as salas e com a estrutura. Queria também agradecer não só ao Castilho ter aceito mais uma vez, mas também ao seu pessoal administrativo, que tem sido assim de uma qualidade digna do nível do escritório. Realmente eles foram fantásticos, tornaram a nossa vida muito mais fácil. Queria também agradecer os patrocinadores, CBA, CBA e o Joaquim Muniz e o Grambal Advogados. O Joaquim agora vai anunciar os 5 melhores oradores do Rio Pre Moot. Lembrando que, para concorrer ao prêmio, precisava ter falado uma vez pelo Climate e uma vez pelo Respondent. Nós vamos anunciar do 5º ao 1º lugar. Logo na sequência, o Gabriel também vai encaminhar para as equipes as notas de cada um dos rounds e as estatísticas. Mas isso talvez demore algumas horas, talvez só ocorra amanhã, mas vai chegar.
Então, agradecendo vocês no sábado, domingo de carnaval de manhã, plateia cheia, o trabalho de vocês, assim, a gente chegou para organizar 8 horas da manhã, tinha uma multidão de semifinalistas ali, isso dá uma alegria no coração, realmente vocês estão no caminho certo e o nível é altíssimo, né? Lembrando, então, que não são exatamente as melhores notas, porque quem fez 2 vezes a mesma posição não concorre. Então, só concorreu quem fez as 2 posições, que isso é a regra do MUT. Então, o prêmio, né? Os 5 ganhadores ganham a bolsa para o curso de arbitragem do CPA desse ano. Então, foi um prazer aí de contar com vocês 5. 5º lugar, da Federal da Bahia, a Cristiana França Alves. Quarto lugar, da PUC de São Paulo, o Fernando Nolasco Mentoni. O 3º lugar, também da Federal da Bahia, que teve mais integrantes aqui na lista, João Vitor Machado Duarte. Segundo lugar, para aumentar aí o nervosismo, mostrar como é que o negócio foi parelho, é o Gabriel Edson Figueiredo. Em primeiro lugar, também nessa mesa, a Júlia Lopes de Nato.
Bom, acho que isso demonstra, né, o quanto foi difícil. Aqui a gente está com o 1º e 2º lugar, realmente foi muito difícil. Primeiro, quero elogiar, é impressionante, né, como vocês foram bem e como que, não só no inglês, no detalhe, nos documentos, na técnica, e a gente, né, que trabalha com isso todo dia, vocês têm um mundo pela frente, né? Vocês estão começando agora e já estão com toda essa experiência. Então, parabéns, realmente, porque vocês estão, né, como vocês falam, estão no caminho certo, porque para estar aqui hoje, né, e com esse grau de profissionalismo, realmente, parabéns.
É unânime, os 4 foram muito bem em todas as técnicas que a gente costuma avaliar, né? O contato, o olhar com o tribunal, se dirigir direto ao tribunal, a interação entre vocês na passagem das informações, impecável. As 2 equipes, de verdade.
Um nível altíssimo, é muito difícil para a gente escolher tudo perfeito, impressionante. Cada ano é um nível mais alto, cada ano melhora e realmente muito impressionante. Assim, para a gente que já viveu alguma coisa, é muito bacana a gente ver essa nova geração vindo de uma forma tão forte, tão brilhante. Parabéns.
A gente tem, né, que escolher um, infelizmente, e a gente escolhe os 5.
Parabéns.
Parabéns a todos.
Parabéns.
Ano que vem, pessoal.
Parabéns, você vai carregar o presente agora pra vocês.
Ai, pelo melhor possível.
Parabéns.
Não, eu peguei só na
Tinha uma proporção, você.
Não, eu